Welcome, everyone, to this explainer on the Industrial Relations Code 2020. I'm your host, and today we are going to master the absolute letter of the law. You see, for decades, Indian labor jurisprudence was scattered across multiple confusing acts. But in 2020, the entire landscape fundamentally shifted. We are looking at a monumental consolidation of rights, regulations, and industrial harmony. So, if you're a law student, a legal professional, or simply an employer wanting to stay on the right side of the law, pay close attention. All right, here's our roadmap. We're hitting 5 critical pillars today: trade unions, industrial disputes, authorities and resolution, standing orders, and finally, disciplinary proceedings. Let's get right into it. Starting off with Pillar 1, the rise of trade unions, specifically covering their history, registration, and rights. Let's trace how this whole thing evolved. We started way back in the dark pre-industrial era, basically pure master-servant exploitation. Then, around 1919, the ILO stepped in to set some much-needed international standards. That led to our Indian Trade Unions Act of 1926, giving us some rudimentary, basic protections. But the real game changer? That's 2020. The IRC literally swept up 29 scattered central labor laws and consolidated them into 4 modern, streamlined labor codes. It's a massive shift.
So, what exactly is a trade union? Simply put, it's any combination regulating relations between workers and employers. But here is the monumental shift under the IRC 2020, the concept of the recognized negotiating union. Now, to be the absolute sole negotiating body, a union must prove it holds 51% membership of the workers in an establishment. If nobody hits that 51% mark, well, a negotiating council is formed out of unions holding at least 20% each. It's pure, strict, statutory math dictating bargaining power.
Which brings us perfectly to our first landmark case, All India Bank Employees Association versus National Industrial Tribunal. The facts here are intense. Bank employees went on a massive strike, and management fiercely fought back with dismissals. This raised a huge constitutional issue. Is the right to strike actually a fundamental right under Article 19(1)(c) of the Indian Constitution? The article guaranteeing the right to form associations.
The Supreme Court of India gave a resounding, absolute answer. Forming a union? Yes, that is your fundamental right. But the strike itself? No way. The right to strike is strictly a statutory right. It is heavily, heavily regulated. You can't just walk out on a whim. You are entirely bound by the conditions of the law, like strict notice periods. Break those, strike illegally, and you instantly lose your statutory immunity. Moving right along to Pillar 2, managing industrial disputes, looking at prevention, layoffs, and retrenchment. Now, the legal definition of an industrial dispute carries profound gravity. We're talking about any dispute connected with employment, non-employment, or conditions of labor. And crucially, under the IRC 2020, even an individual dispute over discharge, dismissal, or retrenchment is explicitly deemed to be an industrial dispute. Make no mistake, these are the absolute core triggers of labor litigation in our courts today. And here's a vital legal distinction that catches so many employers completely off guard: layoff versus retrenchment. A layoff is purely temporary. Think machinery breakdown or a sudden lack of raw materials. The worker actually stays on the muster roll and is entitled to 50% of basic wages plus dearness allowance. Retrenchment, on the other hand, that is permanent termination for any reason other than disciplinary punishment, and that carries a heavy, heavy price tag: 15 days of wages for every single completed year of service. Let's look at our second landmark case to see this in action. Workmen of Subang Tea Estate versus outgoing management. Here, a tea estate permanently closed its doors. The management simply washed its hands, claimed genuine business failure, and flat out denied the workers any closure compensation. The burning issue before the court was, when an establishment permanently closes, what exactly are the financial obligations to a suddenly ruined workforce? The Supreme Court laid down an unshakable mandate here. Closure compensation is absolutely mandatory. In the eyes of the law, it is equated to retrenchment compensation. Employers cannot magically escape their financial obligations just because they decide to shut down, unless, of course, it's a genuinely unavoidable circumstance, like a complete act of God. Now the IRC 2020 forcefully levels the playing field when things turn hostile. Just look at the strike versus lockout dynamic. A strike, naturally, is the worker's weapon. A lockout is the employer's weapon. But under this new code, both sides are bound by the exact same stricture: a mandatory 60 days notice before taking any action. Absolutely no sudden moves are permitted anymore. All right, stepping into Pillar 3, authorities and dispute resolution. covering conciliation, arbitration, and tribunals. We have a very clear, structured hierarchy here. It kicks off at the ground level with the Works Committee. That's basically an advisory body. If that doesn't work, the conciliation officer steps in to mediate. Still murky? A court of inquiry investigates the facts. But if voluntary arbitration completely fails and no settlement is in sight, the dispute escalates to the ultimate authority, the powerful industrial tribunal, where the decision is absolutely final and binding. Which brings us to a legendary constitutional challenge, Bharat Bank LT versus employees. In this case, an industrial tribunal forced a bank to pay specific bonuses and allowances. While the bank was furious, they challenged the very existence of this power, arguing, hey, fixing wages is a legislative act, not a judicial one. The tribunal is violating the fundamental separation of powers. But the Supreme Court completely shut that argument down. They delivered a resounding confirmation that industrial tribunals wield massive, binding, quasi-legislative power. They don't just sit around interpreting contracts, they can actually create net new rights and obligations to enforce industrial peace. Their awards are binding as the absolute law between the parties, period. Let's pivot to Pillar 4, Standing Orders and Rules, the statutory force in the workplace. To understand this, look at the Western India Matchco case. Management transferred workers from one department to another, directly relying on a clause in their certified standing orders. The workers violently protested, claiming management totally overstepped. So, the issue is clear. Can standing orders legally empower management to enforce transfers against the workers' explicit wishes? The Supreme Court ruled that yes, certified standing orders have undeniable statutory force. If the official rulebook says management can transfer you, well, they can. But, and listen, this is a massive but. The court explicitly stated that any ambiguity in these orders absolutely must be construed beneficially for the workers. You cannot use vague, tricky wording to exploit the workforce. Finally, we arrive at Pillar 5, Disciplinary Action and Termination, the Rules of Natural Justice. The domestic inquiry is a rigorous, unforgiving process every employer must flawlessly execute. Let's break it down. Step 1. Issue a precise written charge sheet. Step 2. Give the worker sufficient time to prepare a proper defense. Step 3. Conduct a fair hearing before an inquiry officer. Step 4. A formal findings report must be submitted. And Step 5. Only then can management pass an order of proportionate punishment. Let me be absolutely clear. Skip even one step, and your dismissal order is legally dead on arrival. This procedural strictness is perfectly captured in our final monumental case, Workmen of Firestone Tire versus management. Here, workers were dismissed after a heavily flawed domestic inquiry. The Supreme Court was essentially asked if the ancient Latin maxims of natural justice, like audi alteram partem, meaning the right to a fair hearing, and nemo judex in causa sua, the rule against bias, actually apply to the dusty, noisy floors of an industrial factory. The answer was a commanding yes. The court powerfully established that natural justice absolutely applies to domestic inquiries. If your inquiry is biased, or if the worker was denied a genuinely fair chance to defend themselves, it completely vitiates, just totally destroys the legality of the dismissal order. The industrial tribunal will throw it right out, and you will be forced to reinstate that worker with full back wages. We've covered immense ground today, from the fundamental rights of unions to the strict, uncompromising procedures of termination, but I want to leave you with a final, provocative thought. With the Industrial Relations Code 2020 strictly codifying unfair labor practices and drastically shifting the thresholds for standing orders and strikes, will these consolidated rules actually forge true, lasting industrial harmony in India? Or have we merely redefined the legal battleground for the next generation? Think about it. Thank you for joining me on this explainer, and keep studying the law.